be seated. And good afternoon, ladies and gentlemen. Again, I'm Judge Battles, and I'll be presiding over the jury selection in just a few moments and over the trial of this case. I'd first like to welcome all of you to the 13th Judicial Circuit and to this courtroom. Again, I'm aware that some of you, this may be your first opportunity for jury service, so these proceedings may be somewhat unfamiliar to you. I know some of you may be a little nervous or apprehensive about the proceedings. So as we go along this afternoon, one of my duties and responsibilities will be to explain to you what your duties and responsibilities will be, and I'll be explaining how these proceedings will be conducted. I am going to take a moment and share with you my opinion that I believe that you're being called upon to perform one of the highest duties of citizenship that we have in our system of government, and that is to sit in judgment of facts which will determine whether someone who has been accused of crimes is guilty or not guilty. And I consider that to be an extraordinarily high duty, and I appreciate all of you being here in honest fulfillment of your jury service. And I appreciate your patience as you've gone about that service. And so now that I've let you come in and sit down, I have to ask you to stand up and be sworn as prospective jurors. If you'd all stand up, raise your right hand, please.
Do you swear or affirm you'll truthfully answer all questions asked of you, so help you God?
Thank you. You can be seated. Now, I know that you've been waiting for quite some time, and again, I just thank you for your patience. Somehow or other, I want to assure you that we've not been wasting time. We've been attending to a variety of matters, and we're going to continue to do that in a fashion that, to the extent humanly possible, is considerate of your time, and somehow I want you to understand that. One thing I'm going to go ahead and say now at the beginning, you've already had instructions given to you. I'm going to be giving you more instructions, in fact, in just another moment, but I'm going to emphasize again at this point that from this point forward, and actually from the point that you were sworn in for your qualification the other day, you must not discuss this case or anything that is occurring or is going to occur here in the courtroom with anyone else. And I'm going to remind you of that throughout the process. These are very important instructions. Now, this is a criminal trial. This is the case of the state of Florida versus Julie Schenecker. Ms. Schenecker is charged with 2 counts of murder in the first degree, premeditated. The elements of these offenses will be explained to you later, and I will now introduce those present. Mr. Traina, for your table, sir.
Good afternoon. My name is Charles Traina. To my right is Jennifer Spradley, and to the far right of this table is Jay Duncan. We're the attorneys that are going to represent Julie Schenecker, who's before the court, standing right here. And assisting us with jury selection will be Michelle McNamara.
Mr. Pruder for the state.
Thank you. Excuse me. Good afternoon. I'm Assistant State Attorney Jay Pruner. To my left is Assistant State Attorney Stefan Udagawa. The lady at the end is an investigative assistant with the State Attorney's Office, Sally Blevins.
Okay, thank you, sir. Our court clerk today is Mr. Benny Carinante. I'll gesture toward him. His job, of course, is to assist with the mechanics of the trial. He swears in the witnesses, prepares paperwork, numbers, and handles exhibits, and assists with a number of miscellaneous duties as we go about the jury selection of the trial process. Our court reporter, Ms. Tamara White, is to my left as I gesture toward her. She, of course, is responsible, and her duty is to accurately take down everything that's said in the courtroom. So I'm going to go ahead and ask your assistance in that regard. Don't do what I'm doing, which is to shake your head in the negative or in the affirmative when responding to questions. Give verbal answers, please, because she has to have something to take down. And that's how we do that. And I'm going to ask your help, too. I'm going to ask that you speak in a really strong voice. And if you believe you're one of those people whose voice doesn't necessarily carry so well, is not that strong, you can stand up to speak. But the important point is we're going to have to be able to hear you up here. So I'm going to ask your assistance with giving us verbal answers and with doing that in all here up here. Now, you've met our bank, you know about security, but they're also here to assist you as you go about your jury service. I know if there's anything they can do to make your stay a little more comfortable, if it's something we're allowed to do, I know we're going to try to accommodate you. Now, before we proceed further, I'm going to read to you a very important instruction. I told you I would do that, and I'll be reminding you throughout the proceedings about some of these rules. And this This instruction is one that contains rules that you are to strictly abide by. In order to have a fair and lawful trial, there are rules that all jurors must follow. The basic rule is that jurors must decide the case only on the evidence presented in the courtroom. You must not communicate with anyone, including friends and family members, about this case, the people and places involved, or your jury service. You must not disclose your thoughts about this case or ask for advice on how to decide this case. I want to stress that this rule means that you must not use electronic devices or computers to communicate about the case, including tweeting, texting, blogging, emailing, posting information on a website or chat room, or any other means at all. Do not send or accept any messages to or from anyone about this case or your jury service. You must not do any research or look up words, names, maps, or anything else that may have anything to do with this case. And this includes reading newspapers, watching television, or using a computer, cell phone, the internet, any electronic device, or any other means at all to get information related to this case or the people and places involved in this case. And again, this applies whether you're in the courthouse, at home, or anywhere else. Now, all of us are depending upon you to follow these rules so that there will be a fair and lawful resolution to this case. Unlike questions that may be asked in court, which will be answered in court in the presence of the judge and the parties, if you investigate, research, or make inquiries on your own outside of the courtroom, the trial judge has no way to assure that they are proper and relevant to the case. The parties, likewise, have no opportunity to dispute the accuracy of what you find or to provide rebuttal evidence to it. That is contrary to our judicial system, which assures every party the right to ask questions about and rebut the evidence being considered against it and to present argument with respect to that evidence. Non-court inquiries and investigations unfairly and improperly prevent the parties from having that opportunity that our judicial system promises. Now, if you become aware of any violation of these instructions or any other instruction I give you in this case, you must tell me by giving a note to one of the bailiffs. Now, it's anticipated that this trial will last about 3 weeks, including this period of time slated for jury selection. So what we're really talking about is the rest of this week and the next 2 weeks. We're going to need a panel of 12 jurors and 4 alternates, a total of 16 individuals who can serve for that period. Let me pause here to tell you that most criminal trials in this circuit are over in just a couple of days or so. It's rare for one to even last past a week, frankly. But every now and then, one comes along which requires me, as the judge, to recruit or draft members of the community to be jurors to hear a case of some length. This happens to be one of those cases. Simply put, we need your help. We recognize that serving on a jury for a 3-week period can present a hardship for some of you, and I'll be giving you a chance to tell me if there are things in your life that you think could keep you from serving. Some of these we may be able to work around, but please understand that your definition of a hardship may not meet the legal definition of a hardship, and I'm required to follow what the law says. Now, having said that, to the extent that we can accommodate your concerns, we'll try to do so. Obviously, this is an important case. We would like to have all of you volunteer for service, but again, please understand that if that is not possible, you may be drafted even though it could prove to be inconvenient. Now, let me give you some examples of hardships. If you're scheduled for surgery, that could be a good excuse. If you are seriously ill or have a condition, medical condition or mental condition that could keep you from serving as a juror, that might be good cause. If you are sole caretaker of a mentally or disabled relative, that might be good grounds. If you are going to be evicted from your home or go seriously in debt, if you miss 3 weeks at work and your employer won't pay you for that, we'll listen to those sorts of issues. However, the fact that your boss feels that you're indispensable to your job may not be enough. We're just going to have to hear the facts a little bit more and make a decision on a case-by-case basis. Basically, the reason for being excused has to border on the calamitous or the severe, and we will leave it up to you to tell us if you think you are in that category, and we'll give you a chance to review your concerns here. Now, we expect to be in session from 8:30 a.m. to approximately 5 o'clock p.m. or so on weekdays, with regular 20-minute breaks and lunch breaks. So that's a little bit about the schedule. Now I'm going to read to you the indictment in this case. But before I do, it's important that you understand that what I'm about to read to you is not any form of evidence. Evidence will come in the form of witnesses who will be called to testify under oath. There may be other exhibits introduced in court. These charges should not be considered by you as any proof of guilt. This is simply the way that people who are charged with crimes are brought to court, and this is a legal document only, not any evidence of guilt. And with that, I'll read the indictment. State of Florida versus Julie Schenecker. The grand jurors of the County of Hillsborough, State of Florida, charged that Julie Schenecker, on or between the 27th and 28th days of January 2011, in the County of Hillsborough, in the State of Florida, did unlawfully and feloniously kill a human being, to wit, Bo Schenecker, with a premeditated design to effect the death of Bo Schenecker or any other human being by shooting him with a weapon, to wit, a firearm. And during the course of the commission of the offense, the said Julie Schenecker carried, displayed, used, threatened to use, or attempted to use a weapon, to wit, a firearm, and actually possessed a firearm and discharged a firearm, and as a result of the discharge, death was inflicted upon Bo Schenecker, contrary to the form of the statute in such cases made and provided, to wit, Florida Statute 782.04 sub 1, 775.087 sub 1, 775.087 sub 2. Count 2. The grand jurors of the County of Hillsborough, State of Florida, charged that Julie Schenecker, on or between the 27th and 28th days of January 2011, in the County of Hillsborough, in the State of Florida, did unlawfully and feloniously kill a human being, to wit, Kayla Schenecker, with a premeditated design to effect the death of Kayla Schenecker or any other human being by shooting her with a weapon, to wit, a firearm. And during the course of the commission of the offense, the said Julie Schenecker carried, displayed, used, threatened to use, or attempted to use a weapon, to wit, a firearm, and actually possessed a firearm and discharged a firearm, and as a result of the discharge, death was inflicted upon Kayla Schenecker, contrary to the form of the statute in such cases may be provided, to wit, Florida Statute 782.04 sub 1, 775.087 sub 1, 775.087 sub 2. Now, with that, I'm next going to turn and read to you some of the laws that I expect to give at the end of this trial. I'm going to go over some of the laws with you now so that you will be clear as to what the attorneys are asking when certain concepts are explored. So I'll begin by discussing the burden of proof and reasonable doubt. The defendant has entered a plea of not guilty. This means you must presume or believe the defendant is innocent. The presumption stays with the defendant as to each material allegation in the indictment through each stage of the trial, unless it has been overcome by the evidence to the exclusion of and beyond a reasonable doubt. To overcome the defendant's presumption of innocence, the state has the burden of proving the crime with which the defendant is charged was committed, and the defendant is the person who committed the crime. The defendant is not required to present evidence or prove anything. Whenever the words reasonable doubt are used, you must consider the following. A reasonable doubt is not a mere possible doubt, a speculative, imaginary, or forced doubt. Such a doubt must not influence you to return a verdict of not guilty if you have an abiding conviction of guilt. On the other hand, if, after carefully considering, comparing, and weighing all the evidence, there is not an abiding conviction of guilt, or if, having a conviction, it is one which is not stable, but one which wavers and vacillates, then the charge is not proved beyond every reasonable doubt, and you must find the defendant not guilty because the doubt is reasonable. It is to the evidence introduced in this trial and to it alone that you are to look for that proof. A reasonable doubt as to the guilt of the defendant may arise from the evidence, conflict in the evidence, or the lack of evidence. If you have a reasonable doubt, you should find the defendant not guilty. If you have no reasonable doubt, you should find the defendant guilty. Now, I'm going to ask, when I ask the next question, to have an audible response from all of you as I present the question. Do you agree with the principle of law that a person is presumed to be innocent until proven guilty beyond a reasonable doubt? Do you?
Yes.
Will you give the defendant in this case that presumption? Will you?
Yes.
Okay. Now I'm going to discuss with you another important constitutional right, and that is the defendant's right to remain silent. Now I need that instruction. The Constitution requires the state to prove its accusations against the defendant. It is not necessary for the defendant to disprove anything, nor is the defendant required to prove her innocence. It is up to the state to prove the defendant's guilt by evidence. The defendant may exercise a fundamental right by choosing not to be a witness in this case. You must not view this as an admission of guilt or be influenced in any way by her decision. No juror should ever be concerned that the defendant did or did not take the witness stand to give testimony in a case. Now again, I'm going to present to you questions related to that, and I'd ask for an audible response from each of you, all of you, as I present the question. Do each of you understand and accept the proposition of law that I just explained to you? Do you?
Yes.
Can each of you agree to follow that law on this issue? Can you?
Yes.
Okay. Now, I'm going to ask a couple of questions so we can begin some individual questioning on a couple of issues. And I'm going to ask the question, and I'm going to basically have you row by row. If you answer yes to this question, stand up so we can take down what in this case is your number, so we can indeed call you individually to speak to you. Now, I've told you that this trial is scheduled to last 3 weeks. The question is, will serving as a juror for that length of time cause any business or personal hardship for you? And again, I'm going to go row by row. And I'm going to ask that you literally stand up if you're in that category. We'll turn to the first row. If you're in that category, if you'd please rise. Okay. Your number, ma'am, your hair. There you go. Okay. Thank you. You can all be seated. We'll turn to the second row. I'll pose the same question. And again, will serving as a juror for that length of time cause any business or personal hardship? If you're in that category in row 2, if you'd please stand up.
Yes.
Thank you. You can be seated. We'll turn to the third row again. I'll ask the question. Will serving as a juror for that length of time cause any business or personal hardship? In the third row, if you'd stand up if that's the case. Thank you. You can be seated. We'll turn to the fourth row, pose the same question. Will serving as a juror for that length of time cause any business or personal hardship? In the fourth row, if you'd stand up if that's the case. Thank you. You can be seated. And finally, in the fifth row, will serving for that period of time cause any business or personal hardship? If you're in that category, in the fifth row, if you'd please stand. Okay, thank you. You can be seated. Now, once again, we're going to be talking to you individually if you're in the category of having responded in the affirmative to that question. Now, next, I'm going to present you a brief statement of the facts of this case that's been agreed to by the attorneys. I'm going to be following that with a question, so I'd ask you to pay close attention. On the morning of January 28, 2011, Tampa Police Department officers arrived at the Schenecker residence in Tampa Palms to check on the welfare of the occupants. Colonel Parker Schenecker, his wife Julie Schenecker, and their 2 children, 13-year-old Bo and 16-year-old Calix, lived at the residence. Colonel Schenecker was deployed overseas at the time. Investigators found Julie Schenecker alive on the pool and eye. The bodies of the Schenecker children who had suffered fatal gunshot wounds were found inside the residence. Julie Schenecker was charged with the murders of her children later that day. Now, having read that statement of facts agreed to by the attorneys, I'm going to be, again, going row by row and asking if you know anything about this case. I'll go to the first row and I'll ask, having read that statement of facts, do you know anything about this case? If you're in that category, if you'd stand up. You can all be seated. We'll turn to the second row, and again, I'll ask, do you know anything about this case? If you please stand up in the second row. Thank you. You can be seated. We'll turn to the third row, and again, I'll pose the question. Do you know anything about this case? Could you please stand up? And you can be seated. Turn to the fourth row. I'll pose the question again. Do you know anything about this case? If you're in that category, please stand up. Thank you. You can be seated. And we'll turn to the fifth row. And again, the question, do you know anything about this case? If so, please stand up. Thank you. You can all be seated. Now with that, as I indicated to you, we're going to be sending you back out into the lobby. We'll be calling you in individually to discuss some of these issues with the attorneys. While you're out there, I'm going to remind you the very important instructions I presented to you, and that is the overwhelming instruction not to discuss this case among yourselves, not to discuss it with anyone else, not to allow anyone to discuss it with you or in your presence. I'm going to go ahead and add to that. You won't be speaking at all with the attorneys and the witnesses in this matter or the defendant until deliberations are done. So if you see the attorneys for any reason and you think, well, they didn't open that door for me or they wouldn't give me advice on where the best place to go to eat is, it's not because they're being rude, it's because they're going to be following my instructions strictly to have no contact in that regard. So I want you to understand that. Once again, you're not to read or listen to any reports about this case from any source whatsoever. And not to do any sort of research, gather information, or communicate about this case or the people or places involved or your jury service through any means, including all those electronic devices. With that reminder of very important instructions, we're going to send you out in the lobby.
All rise.
Okay, you all be seated. The panel's exiting the court. Counsel, are we prepared to begin the individual blood here?
I'm sorry, sir?
Are you prepared to begin the individual blood here?
Yes, sir.
Yes, Judge.
Okay. Number 151 indicates hardship and knowledge. Yes, ma'am, you can have a seat. We're going to let the lawyers ask you a few questions. Please speak up in that strong voice so we can hear you up here.
All right.
Good afternoon, ma'am.
Good afternoon.
You just told us a few minutes ago that service on the jury would be a hardship for you. Can you explain, please?
Yes, sir. Without work for 3 weeks, I would not be able to pay any of my bills. I wouldn't even have gas to get here because there's no way for me to work. It's a 9-to-5 job. Like, I can't work at all then the 3 weeks, which means I can't pay for anything, which means I'm going to be evicted from my apartment. My insurance will be behind, like my car payment will be behind. All my bills will be a month behind, and I won't even be able to make that up. Even if I miss 3 weeks, there'd be no way to make up that money, you know what I mean?
Yes, ma'am.
$30 a day is not enough to pay my bills, because I make $10 an hour at my job.
Okay, thank you. You've been very detailed, but
Thanks.
may I ask you a few follow-up questions? Okay. What type of work do you do?
I work in a office in the marketing department.
Okay. Do you know whether your employer pays for jury service?
No, they do not.
Okay.
I already talked to them about it.
Okay. Are you the sole support of yourself?
Yes.
Do you support any other individuals?
No.
Okay. Do you have any other source of income? Savings or investments that could supplement you?
Not for 3 weeks.
if you were selected to serve on the jury, would the hardship that you've just detailed for us, would that affect your ability to give your full attention to the proceedings and to the evidence?
Yes, I'd be worried the whole time, I'm not gonna lie, I stress so bad.
Well, and I appreciate that. Nobody is minimizing the impact that it would have on you, but we have to ask these questions, ma'am.
Yes, I got you.
You've indicated you've heard something about this case?
Yes, sir.
From what source?
From news and everything. I've lived in Florida my whole life, so of course 2 years ago I heard all about it on the news, and I even heard Monday before I woke up this morning, or that morning, that they were going to be starting jury selection. So I've read pretty much everything you could from the news sources and seen it on TV.
Have you formed any fixed or definite opinion about the defendant's guilt as a result of what you've seen?
Unfortunately, yes.
And what is that?
I do believe she's guilty.
Okay. As the judge instructed everybody before, every defendant is entitled to a presumption of innocence. Is your opinion going to be such that you cannot presume this defendant innocent based upon what you've seen in the news?
I would assume so. I mean, it kind of touches close to me, like, even though I'm not a mother, like, I just get really emotionally attached to things, and like, this whole story to me is crazy. Like, I read all these types of things in the news, and it breaks my heart. So I don't, there might be a way to sway me, but I have a lot of, like, I have a lot of little ties, so like, I don't.
Let me put it this way. Is your starting point going to be that the defendant is guilty and you have to be proved otherwise, or that she's innocent and the state has to prove her guilt?
I would like it to be the way it should be, but unfortunately, like, the way I think, like, even in the back of my mind, I'm still going to think she's guilty the whole time, and I don't really think that's fair, but,
Okay.
you know how it is, right? Like, when you think.
Yes, ma'am, I do that sometimes. Thank you for your candor. I appreciate that, ma'am. No questions? I have a motion.
Judge, I have no questions for this juror.
Thank you, ma'am. Anybody step up?
Thank you.
Move for cause based both on hardship and pretrial publicity.
No objection.
151 is excused for cause based on the state's motion without objection from the defense. 152 indicates knowledge of the case. Okay, so you can have a seat right there. I'm going to allow the attorneys to ask you a few questions and ask you to speak up in a strong voice so we can hear you up there.
Yes, sir.
Good afternoon, sir.
Good afternoon.
You indicated a few minutes ago that you had some information or knowledge you learned about this case from some outside source. Is that correct?
That's correct.
Was that something you recently learned or something from a source in the past closer to the time of the incident?
It was just after the incident when it was on television.
Okay. Was that the sole source of your information, television news?
Yes.
And did you read anything about the case?
No.
Did you do any internet search that led you to this case?
No, sir.
On the broadcast news, did you see any still photography or any video image of the defendant?
Yes, I saw the video image. I believe it was when the arraignment occurred.
Was that in court?
It was at the jail, if I'm not mistaken.
Okay. Did you see any images of her, of Miss Schenecker, outside the court?
Not that I recall.
What impression, if any, did you draw from that video image?
She looked like she was distraught.
And what led you to that conclusion? What did you see?
Well, I saw the shaking of her limbs and
did you draw any conclusion or opinion from that about the defendant's state of mind at the time of the crime?
as I said, I just thought that she was distraught.
Okay. You've heard the judge talk about the presumption of innocence, which essentially means the starting point for the jury must be that she is innocent until the state overcomes that presumption of innocence by proof in court through evidence of guilt beyond a reasonable doubt. Do you understand the concepts?
Yes, I do.
Did you draw any opinion or conclusion about the defendant's guilt or innocence as a result of the reports that you saw?
No.
Is there anything about any information that you learned that would prevent you from giving Ms. Schenecker her presumption of innocence?
No, sir.
Can you hold the state of Florida to its burden of proving her guilt beyond and to the exclusion of every reasonable doubt by evidence in court?
Yes, sir.
And can you assure us that you would base your verdict on the evidence that is presented in court and to that alone?
Yes, sir.
Do you have any doubt about your ability to do all of those things?
No, sir.
Thank you. Nothing further.
Kelly, questions?
Judge, I have no questions for this juror.
Thank you, sir. You may step out. Panel members next to the courtroom.
I have no motion, Judge.
No motion, sir.
153 indicates knowledge of the case. You can have a seat right there, sir. We're going to allow the attorneys to ask you some questions. Please speak up in a strong voice. Stay.
Good afternoon, sir. You indicated just a few minutes ago that you had some information or knowledge you learned about this case from some source outside the courtroom before you came in today. Is that correct?
Yeah,
Was that something you learned recently or closer to the time of the events in 2011?
I seen the TV something, but I don't know too much about this.
Okay, was that something you saw recently or a few years ago?
Like a few years ago.
Okay. Judge Battles just a few minutes ago read kind of a summary or synopsis of what this case was about. Do you recall that?
No.
Just a few minutes ago when he told you about the family and about the incident?
I not got the question.
Okay. All right, sir. Tell me what you heard from the TV broadcast.
I see something fast. Like I heard the news, like somebody killed the family. I see the picture, but something like quick.
Okay. What was the picture of that you saw? Do you recall?
I don't remember.
Do you remember whether it was of the defendant, Ms. Schenecker?
Yeah, I remember the face. Yeah.
Okay. Do you remember what situation she was in when you saw that?
No, really no.
Have you drawn any kind of opinion or impression about the defendant's guilt as a result of what you saw on TV?
I heard only. I know this because I know forget it. I know it's like I explain. I know too much about it.
Okay. As you come here into court, then can you assure us, promise us, that you would return a verdict based only on what you hear in court, the evidence you hear in court?
To me again, I don't know. I understand what they say.
Okay, sir. Let me ask you a few questions, sir. Is Spanish your primary language?
Yeah.
Are you having any difficulty understanding the court's instructions?
Yeah, a little bit.
Okay. Can you give me an idea of how much you understood and how much you did not understand of what the court told everybody a few minutes ago?
I got something, but I don't know, like 50, 70%.
You did not get...
Not 100%, whatever. Everything you say 100%, I not got it.
Okay. About how much do you think you missed or did not understand?
30%, you say, or 50,
Oh, okay.
40% maybe.
Somewhere around there? Okay.
Yeah.
So Do you think that would affect your ability to listen to and understand the testimony and evidence?
I think, yeah.
Okay. Thanks for your candor, sir. No questions.
Any questions, sir?
Judge, I have no questions.
Thank you, sir. You may step out.
Thank you.
Panel members, exit the court.
Move for cause based upon language difficulty, sir.
No objection.
Motion to state without objection to the defense. 153 instruct for clause. Next is 155 indicates hardship and knowledge. We're going to allow the attorneys to ask a few questions, and I'd ask you to speak up in a strong voice so we can hear you, okay?
Yes, sir.
Good afternoon, ma'am. You indicated a few minutes ago that service on the jury for the next 2.5 weeks approximately would cause a hardship. Could you explain for us?
Sure. I'm a hairstylist, and I'm not paid hourly, so I'm based on commission. And I don't, I've actually had to cancel all of my clients since Monday because of coming here. So if I have to come for the next 3 weeks, I won't have an allowance. So it's my livelihood, and I won't have an income.
Okay. That's very plainly understood, but let me ask you some following questions, if I may. Are you the sole support for yourself?
Yes, I am.
Do you have any other source of income, perhaps family or savings or investments of any sort?
I do not.
Could you explain in we all understand that missing salary or paychecks or commissions affects one's lifestyle or livelihood. Can you explain for us how it would affect your livelihood and ability to meet your obligations?
Well, some of my clients have gone to other people, so for the future I may not get them back, and it would affect me in the long run. I don't make any money if I don't do any services on my guest. And like I said, I have that risk of them going to somebody else and then affecting me in the future. And if I don't make money, I can't pay my bills.
Okay, and I guess I wasn't specific enough. That's what I was trying to find out from you, is the extent, without going into like dollars and cents,
Sure.
the extent and nature of your financial obligations that you would be unable to meet. If you could explain that for us.
Like money?
Like, do you have rent or mortgage? Do you have?
Yes, I have a lot of medical bills. I have rent, cell phone, car payment.
Okay.
Just
All right. If you were nonetheless chosen to serve on the jury, would that hardship presented by your service, would that affect your ability to serve as a fair and impartial juror?
no.
If you were selected despite that hardship, would it cause any difficulty for you in focusing or paying full attention to the testimony and the evidence that you would be presented in court?
Yes.
Okay. Do you think that would affect your ability to serve as a juror in this case?
Yes, because I would be worried about my future.
Okay, ma'am. And let me move quickly to another topic, which was you've learned something about this case in the past. Is that correct?
Yes.
From what source?
The news.
Recently or near the time of the incident in 2011?
I remember it from the time in 2011, and then recently, and of course with my guests, they talk. So.
Okay. Have you formed any opinion about Ms. Schenecker's guilt or innocence as a result of what you've seen on the media and what your customers have talked about?
Yes, I have.
What is that opinion, ma'am?
That she's crazy.
Okay.
She's insane for killing her kids.
All right. Is that an opinion that you strongly hold?
Yes, I do.
Okay. Is that an opinion that is one that you would not be able to set aside at the beginning of the case?
No.
Okay. Do you think that would affect your ability to serve as a fair and impartial juror in this case?
Yes.
Thank you. No questions, and I have a motion.
No questions, Counsel?
No questions, Judge.
Thank you, ma'am. You may step up. Please exit the courtroom.
Statements for cause on both hardship and pretrial publicity.
No objection, Judge.
Motion granted, excuse for cause, 155. 156 indicates hardship and knowledge. Good afternoon, a few questions, please respond in strong whistling here.
Good afternoon, ma'am.
Hello?
You indicated that service on the jury would present some type of hardship, is that correct?
Correct.
Would you explain the nature of the hardship?
I have a trip out of the country in 2 weeks, for a week, out of the country.
What's the date of your departure?
The 19th,
Okay. Which is a Monday, is that correct?
correct.
Okay. When we talk about 3 weeks, we include this week. We are anticipating that the trial would be completed by that last workday of the previous week, the 16th.
Okay. I only stood up because I wasn't sure if it went over, how that would...
Oh, no, that's quite all right. We'd rather you err on the side of caution, but I just wanted to explain that to you.
Okay.
If that schedule runs true to our estimate, does that then remove the hardship?
Yes.
Okay. Let me move on to the other topic that you stood up for, which is knowledge about this case from some outside source. What was the source of the information you received?
The source was TV news.
And did you see reports about this recently or near the time of the offense in 2011, or both?
Both.
Okay. Judge Battles read a synopsis of the case a few minutes ago. Do you recall that?
Yes.
Okay. I want to talk to you briefly about a couple of the principles Judge Battles addressed with you, and that is, the first one is that the fundamental principle that the defendant is presumed to be innocent, which means the starting point for the jury is that she is innocent, and that presumption of innocence stays with her up until the time that the state of Florida proves her guilt beyond a reasonable doubt by evidence in court. Do you understand those principles, ma'am?
Yes.
Okay. Tell me, please, everything that you can recall seeing in the media or reading in the media about this case or about Ms. Schenecker that is in addition to or different from what Judge Battles told you a few minutes ago.
I guess just seeing it on the news and just the fact that, I believe she said that she had done it. And I just can't understand how that could happen. But as far as my knowledge, it's basically just watching the news, and that's pretty much it.
Okay, when you indicate that you believe she said she had done it, what did you interpret that report to mean? Not the content so much as the manner that was reported.
I just read that in the paper.
Okay. Have you formed a fixed or definite opinion as to the defendant's guilt or innocence as a result of what you've read or seen?
I believe I have.
And what is that?
Guilty.
Do you hold that with strong conviction?
Yes.
Okay. Is that an opinion that you hold with such a conviction that you think it may affect your ability to presume Ms. Schenecker innocent?
Yes.
Okay. Would that, in your mind, prevent you from being a fair and impartial juror?
I think so.
Okay. Thank you. No further questions, ma'am. I have a motion.
I have no questions, Judge.
You may step out.
Okay, thank you.
She's asking to close.
State of Florida moves on pretrial publicity, and it appears that she, although she didn't couch it in that terms, appears to indicate she had heard information about a confession.
No objection, Judge.
156 is struck for cause. 157 indicates not. Yes, ma'am, you can have a seat. We're going to allow the attorneys to ask a few questions, and I ask you to respond in a strong voice so we can hear you up here.
Good afternoon, ma'am. You indicated a few minutes ago that you had information or knowledge about this case from some source before you even came to court. Is that correct?
Yes, just from the news.
And was that something you learned of recently or near the time of the event in 2011?
2011, I just had heard about it. I didn't know any details on it.
Okay. Did you see anything in the news recently in the last week or two or three?
Just that there was an upcoming trial.
Okay. Did that news report give you any details about the case or about the incident?
No.
Okay. Ms. Schenecker is presumed innocent by the law, by our Constitution.
Yes.
Which means your starting point as a juror has to be that she's innocent. And that sticks with her until the state of Florida overcomes that presumption of innocence by proving her guilt in court with evidence beyond and to the exclusion of every reasonable doubt. Do you understand that, ma'am?
Yes.
Okay. With that in mind, can you tell me everything that you recall hearing about the case back at the time of the event that is any way different from what Judge Battles told you a few minutes ago, or is in addition to? Do you understand what I'm asking for? Any additional facts that you've come to court with?
I really didn't hear anything different than what he said, that just the 2 children had been shot, and that was all that I heard. I didn't know any details surrounding it.
Okay. Did you see one report or multiple reports?
I don't really watch TV that much, so I just had seen it like on the 10 o'clock news, just that the incident had happened.
Okay. Do you recall seeing any type of video or photographic still images of the defendant in that report, or any report?
I think back in 2011, or when it happened, I remember them like showing her. It's very vague remembrance of it. I don't remember a lot surrounding it. I just remember this was the woman that was arrested for what happened.
Okay. From seeing that image on TV, did you draw any conclusion or opinion as to the defendant's guilt or innocence, or her state of mind at the time of the events?
No, because I didn't know any details. I didn't know why it happened. I didn't know facts surrounding it, that it just had happened.
Any fixed or definite opinion about the defendant's guilt or innocence as a result of what you saw?
No, I mean, I try to hear all the facts before I try to form an opinion.
Can you start at that starting point that our Constitution requires, meaning can you presume her innocent at the start of the trial and say that the state's got to prove her guilt to me beyond and to the exclusion of every reasonable doubt.
Yes.
Can you Marshall